Hello, dear students. Welcome in this lecture. Our previous lectures we were discussed about the right to equality. Article 14 embraces within its special general principles of equality. And now we will read the specific application of this rule. Article 15 is an example of a specific application of this rule. Now, our important topic is prohibition of discrimination against citizens. It means the provisions of Article 15 is related to prohibition of discrimination against citizens. Article 15, titled as Prohibition of Discrimination on Grounds of Religion, Race, Caste, Sex, or Place of Birth, contains provisions of particular application of the general principle of equality of treatment embodied in Article 14. It prohibits discrimination against citizens on the ground only of religion, race, caste, sex, place of birth, or any of them. It may be noted that Article 15 secures the right against discrimination only to citizens, and for that non-citizens cannot invoke the provisions of this article. This is the important provision of Article 15, that it secures the right against discrimination only to citizens. Okay? When we see the provisions of Article 15, Clause 1, we see that the provisions said that the state shall not discriminate against any citizens on ground only of religion, race, caste, sex, place of birth, or any of them. Discrimination against one person necessarily involves discrimination in favor of other. The term thus includes comparison, where two citizens placed more or less similarly in all material respects. Any state action placing one of them alone under a disadvantage, there would be discrimination against him within the meaning of Article 15. Discrimination in the context of Article 15 also means classification among persons or things, and also reservation for some of the members of a group or a class. If any such classification or reservation is based on any of the grounds mentioned in Article 15(1), for example, religion, race, caste, sex, or place of birth, it would be violative of Article 15, Clause 1. This is the important thing, that Article 15, Clause 1 is in absolute term. Okay? This is in absolute term. Discrimination against citizens on ground of religion, race, caste, sex, or place of birth, or any of them by the state is prohibited under Article 15 Clause 1. So, Article 15(1) is in absolute term. Now, we have to know the essential element of Article 15 Clause 1. That you have to know that what are the essential element of Article 15 Clause 1. It's important to know if you want to understand this article. So the elements are: first, prohibition is on the state not to discriminate. The second is, right is given to citizens. And the third is, this right is guaranteed against discrimination in matters of rights, privileges, and immunities pertaining to a citizen. Now, this is important information about this article, that this is only for citizens. The provisions of Article 14 was for everyone. They may be citizens, they may not be citizens. That provision was for person. And the provisions of Article 15 is only for citizen. In the case of Kathi Rening Rawat, the Supreme Court said that in this article the important word is only. The important word is only. When you read the provision of this article, you see that the provision said that the state shall not discriminate against any citizen on ground only of religion, race, caste, sex, place of birth, or any of them. Then, in the case of Kathi Rening Rawat, the Supreme Court said that in this article the important word is only. If the discrimination is based on some grounds not connected with religion, race, caste, sex, or place of birth, but some other rational factors, the discrimination would be valid. So, the meaning of only is important. This article said that only. Yani, it means if the discrimination is based on some grounds not connected with religion, race, caste, sex, or place of birth, but some other rational factor, the discrimination would be valid. For example, you can see the case of D.P. Joshi versus State of Madhya Pradesh. In this case, a rule framed for admission to the state medical colleges required the payment of capitation fee from non-Madhya Pradesh students. The students of Madhya Pradesh were exempted for the payment. So this was the fact. The student of Madhya Pradesh and the student of other states. There is a classification, and the ground is residence. So, the rule which discriminated on the ground of residence was upheld by the Supreme Court as not violative of Article 15 Clause 1, because the base of classification is residence. The Supreme Court said that place of birth is different from residence. So, the importance of word only is this. If the discrimination is based on some grounds not connected with religion, race, caste, sex, or place of birth, but some other rational factors, the discrimination would be valid. And the case of D.P. Joshi versus State of Madhya Pradesh is the example of this point. You see, in this case, the rule framed for admission to the state medical colleges required the payment of capitation fee from non-Madhya Pradesh students. The students of Madhya Pradesh were exempted for the payment. The rule which discriminated on the ground of residence was upheld by the Supreme Court as not violative of Article 15 Clause 1. Court said that place of birth is different from residence. Now, after it, we will see the provisions of Article 15 Clause 2. And what is important in this article? No discrimination as to use for access to public place. This is the provision of Article 15 Clause 2. No discrimination as to use or access to public place. Clause 2 of Article 15 is a particular application of the general principle against discrimination embodied in Clause 1. While Clause 1 forbids discrimination against citizens in all matters, Clause 2 deals only with case of discrimination as regard to the use or access to public place mentioned in this article. This is the important provision of Article 15 Clause 2. Now, what are the elements of Article 15 Clause 2? So, you can see that Article 15 Clause 2 contains provision of a general nature and is not confined to state only. Accordingly, the essential feature of Article 15(2) may be pointed out as follows. Citizens shall not be subjected to disability, liability, restrictions, or conditions with regards to access to shops, public restaurants, hotels, and place of public entertainments, and use of wells, tanks, bathing ghats, roads, and place of public resort. The place defined in the article are: first, mentioned wholly or partly out of state funds, or secondly, dedicated to the use of the general public. It follows that a private tank, well, or a bathing ghat does not come within the purview of Article 15 Clause 2(b). Now, this is the important point of this article. The place defined in the articles are first mentioned wholly or partly out of state funds, or second is dedicated to the use of the general public. It follows that a private tank, well, or a bathing hut does not come within the purview of the Article 15, Class 2B. There is a very interesting case, People Union for Democratic Rights versus Union of India. In this case, the Supreme Court ruled that whenever any fundamental right which was enforceable against private individuals was being violated, it would be the constitutional obligation of the state. This is the important point. It would be the constitutional obligation of the state to take necessary steps for the purpose of interdicting such violation and ensuring observance of the fundamental rights by the private individual who was transgressing the same. Now, the important point is that it would be the constitutional obligation of the state. It means the provision that a private tank, well, or bathing hut does not come within the purview of Article 15, Class 2B is an important point of this article which we have to understood. If the place defined in this article are mentioned wholly or partly out of state funds, are dedicated to the use of the general public, then according to People's Union for Democratic Rights versus Union of India, whenever any fundamental right which was enforceable against private individuals was being violated, it would be the constitutional obligation of the state to take necessary steps for the purpose of interdicting such violation and ensuring observance of the fundamental rights by the private individual who was transgressing the same. These are the important elements of the Article 15 Class 1 and 15 Class 2. We have many things to discuss about this article, but we will continue it in our next lecture. Thank you.